Welcome to Dorsey and Whitney's webinar on advertising law basics, part 2, sweepstakes and contests. I'd like to introduce Charlene Krogh, a partner and practice group leader in Dorsey's trademark group. Charlene?
Hi, thank you everybody. Thanks for being here. Good morning, good afternoon, depending on where you are. This is our second in a 3-part series on advertising law basics that Fara and I are conducting. Today, we're going to cover sweepstakes and contests. We hope to give you a good overview on a basic introduction to the topic. It's pretty vast. Obviously can't cover everything, but hoping to give you the essentials here in this discussion. So a couple of housekeeping items. Fara, you want to flip to the next slide? Today's program is 60 minutes. Materials and attendance form are available for download from the reminder email that should have been sent to you from events@dorsey.com. You can return the completed attendance form to attendance@dorsey.com. The hosts are posting this in the chat right now as well. You can submit questions using the chat function. If I see them or Fara sees them, we'll try to answer them real time if we can. And if time doesn't permit, we won't answer them and we'll try to get back to you at another time. You can definitely reach out to either of us if you have questions or want to continue this discussion. Happy to chat further. Fara, I was introduced, but Fara Sunderji, my partner, was not. She's a partner in our New York office. She practices in the trademark, copyright, and advertising group with me and is very much a specialist in this area. I'm here as her wingman today, a specialist as well, but Fara is absolutely the go-to in the firm. So I'm super happy that she's here with me. Great. So with that, I think we can get started. Great. So types of promotions. There are essentially 4 types of promotions. I'm going to start from the bottom up here a bit. So raffles are a very unique type of promotion that can only be run by an eligible organization under certain rules. We're not really going to cover charitable raffles today. It's a pretty deep topic that I think could take an entire CLE on its own, and it's very specific. So we're going to move that aside for the moment. Moving up the list to illegal lotteries. A lottery is really only legal if it's sponsored by a government. One of the points of this discussion today is to keep you out of running an illegal lottery. The ways to do that, 2 ways to do that, is to run a sweepstakes or a contest of skill. Those are the 2 types of promotions we'll focus on today. A sweepstakes is when a prize is given away through chance and no consideration is required. And a contest of skill is when a prize is given away with ability or effort, or there's some skill required. During this webinar, Fara and I are going to say the word promotion that will generally to encompass both sweepstakes and contests of skill. So just so everybody knows that it's kind of an overarching, all-encompassing term we'll use throughout the webinar here. So I mentioned the goal is to structure your promotion appropriately under federal and state law to avoid characterization as an illegal lottery. On this slide here are many federal and state laws that provide guidance or rules for the structure of promotions and how they can be run. This is not an exhaustive list by any means. I think if we just had the state statutes in this slide, it could take maybe the whole 27-page deck. But it is a good starting point, and this is a good place to start considering, or a good place to start for considering the different types of laws. I'm not going to talk about these in depth, but I'll touch on a few of them here. The Deceptive Mail Prevention and Enforcement Act was passed in 2000. It applies to sweepstakes that are made available or promoted through direct mail. If you intend to promote your promotion or run a promotion through direct mail, definitely want to reference that act. The Federal Trade Commission, specifically Section 5, most of us on this webinar may be familiar with that section. It prohibits unfair methods of competition and protects against deceptive trade practices. And then there's FTC guidance that goes along with the act, of course, that provides a lot of guidance and rules around promotions, contest sweepstakes, and also terms required for the official rules for sweepstakes, things like sponsor information, duration, prizes, value, eligibility, things like that. Can spam is basically the law that governs commercial electronic mail messages and creates a national standard for sending email, the primary purpose of which is to advertise or promote a commercial product or service. So if you are using electronic mail messages as part of your promotion, definitely want to peek at that. COPA, Children's Online Privacy Protection Act, state statutes I mentioned. Many states have them, not all states have them. They vary widely. Their interpretation varies widely, and they are broad enough in some cases to encompass nearly any type of promotion. So our recommendation is always to review and ensure compliance with each state statute in which you are running a promotion, or exclude states in which you aren't complying. And Fara, I think we'll go a little bit deeper into some of those state specific rules later. Foreign regulations. So everything we're going to discuss today is very US centric and is from the US perspective. I would advise, if you are running a promotion that will touch a foreign jurisdiction, that you consult with local counsel to be sure that you are adhering to whatever guidelines, rules, and regulations may exist in those foreign jurisdictions. Fara and I were discussing this, that a lot of foreign jurisdictions consider contests to be gambling, and in some jurisdictions they're prohibited entirely. So absolutely, I think critical to consult with local counsel if you'll be running something outside of the US.
And Charlene, I think another important point on that is when you set up your official rules, you should actually say who can enter and who can't enter. A lot of clients are running contests and sweepstakes online, and so if you launch a promotion on the web or on social, and you just leave it open to everyone, you actually could get caught in the crosshairs of some foreign jurisdictions. You're going to have foreign entrants if you have foreign customers, say, following your Instagram page and you run an Instagram promotion. So it's best to limit the entrance to U.S. residents and go from there. We definitely have a fair number of clients who want to do cross-border promotions. They're not impossible, they're just a little bit more difficult. I will say that doing a cross-border promotion with Canada, it's fairly easy. The laws are very similar, but doing a cross-border promotion, say, between the US and Italy, that's really difficult. Not something I recommend. It makes it, the Italian law is very different than the United States law on these things. And, for example, one point that I've seen local counsel advise us on is that the drawing for a sweepstakes actually has to happen in Italy. Now, that might be sounding fun to somebody in your marketing team, but not very practical to actually have the drawing take place in Italy and have all the rules translated into Italian and have bonds posted and things like that in Italy. It makes it a lot more difficult.
Yeah, I would say it probably can't be overstated that because of that kind of online nature of life right now, and the fact that it's become more appealing to advertise online, it's very easy and you can reach a large group of people, that it's critical, right, Fara, to create rules for eligibility that would make sure that whatever you have done your research on is really all that there is to comply with, by structuring the promotion in a way that makes sure it's clear. Yep. So the three-legged chair, these are the three pillars or elements to determine what type of promotion you're running, whether it's legal or illegal under the rules that apply to it. So if you have all three of these, consideration, chance, and prize, it's characterized as a lottery. And if you're not a government, you're running an illegal lottery. So taking any of these, one of these three elements out of the equation will put you outside of the characterization of a lottery. So theoretically, you could remove number 3, which is the prize. I like to go from the bottom up. I don't know, Fara, if you theoretically you could remove the prize, right? Which is to avoid characterization of your promotion as an illegal lottery. But as a practical matter, that may not make a lot of sense. It might defeat the entire purpose of the promotion, and ultimately it just might not be worth pursuing. Sweepstakes are generally not considered lotteries because you've removed element 1, which is consideration. It's a random drawing for a prize. And in those types of promotions, the participant is not required to provide something of value. Where a contest of skill is concerned, it's not a lottery because you've removed number 2, which is chance. The prize is awarded based on the skill of the participant or the entrant, and something that they have done. We're going to talk about each of these 3 things separately now. Fara is going to turn to them. Fara, there's a question, if you could take one quick. It says, what do you think about some of the companies that will conduct a global promotion for the client? That seems like a very tricky proposition, but.
Whenever a client comes to me and says, we want to run a global promotion, I tell them you're taking a lot of legal risk if you don't check with foreign counsel. Sometimes the way to do this is to narrow down to the key jurisdictions that you have customers in, because you maybe you don't need to open this contest to folks in Nigeria, but you really want to open it up to folks in Japan. And so then we can cut down on the expense by only contacting counsel in Japan, and that's one way to do it. But you are definitely taking a pretty big risk when you have a global promotion. I can't stress that enough. It's definitely a risk. Whether you're actually going to get government enforcement action against you, I can't answer that question. How the jurisdiction works, whether they have a right to come after you, but a lot of these laws fall under the gambling laws, and they have criminal penalties, and so it's taking a big risk.
And I would say that if we're thinking about the idea that there's companies out there who will conduct, whether it be global or not, promotions for a client, I think that is an interesting thing to consider. But based on my understanding, far as those companies are not the ones who are on the hook for the footfalls you may have running the promotion wherever it may run. So still falls on the marketer and the person running the promotion, all of that risk and sort of liability. And even if, like Fara said, even if there isn't some sort of action pursued, whether it's government action or consumer action, I think the PR risk, which we'll see later in a couple of examples alone, could be enough without any other sort of quote unquote action that's happened. The purpose of the promotion is to promote the brand. And if it goes horribly wrong, that in and of itself is its own big issue.
Yeah, and PR risks obviously are not covered by indemnification. You can have an indemnification clause with your sweepstakes company who's running your global promotion for you, and maybe they'll pay all the fines and such. But I guess the 2 things that aren't covered are the reputational risk, the PR issues, and if there are criminal charges, obviously indemnification clauses don't cover those things. And so I say take that with a large grain of salt and decide your risk profile there. But that makes me nervous as a lawyer. All right, so let's dive into consideration. I think most of the folks on the line are in-house counsel. You'll remember from law school, consideration can just be a simple payment or a fee. Sometimes it's not that easy. I think, the marketing folks come back to you guys with these great ideas. Oh, we want to do this really interesting promotion where we have folks post a picture of themselves with a picture, with our product in the picture. Well, how did they get the product? They probably had to buy the product. So you're essentially requiring a purchase. What about a past purchase? Oh, if you've already made purchases, if you're part of our club, if you've already paid an entrance fee, something like that. Sometimes that's how you decide who's going to be able to enter the promotion. So those things can be a consideration, and that can sort of create some issues for you down the line, as we're going to discuss. It's really almost anything of value to a sponsor. So I get a lot of questions from clients. What about surveys? I think the law on surveys and my thinking about surveys, and when I say surveys, I mean, so the marketing people say, okay, great. Why don't we give away a $100 gift card if folks will fill out a survey for us? We'll get some really valuable, interesting data or maybe they have to sit through a sales presentation. That's another one. My thinking has evolved on these over the years. I think that we used to tell clients, 15 minutes to fill out a survey or sit through a sales presentation was probably okay. I think through the passage of time, people's attention spans have gotten much shorter. My limit is sort of 5 minutes now. It's not an easy line to draw, but you got to think about folks and their time and how long it takes people to fill out things and how detailed they're getting. If you want somebody to fill out a 3, question survey, I think that's okay. I think that makes that seems to be on the good side of stuff. And filling out a survey, or not a survey, sorry, but just filling out an entry form with your name, your address, your email address, and some other, biographical data. I think most states have said when they've weighed in on these things, they've said that that's okay. And so that really makes it okay. But so surveys a little fuzzy. It's better to look at the specific facts and circumstances. But I sort of draw my line at about 5 minutes. If you tell me somebody's got to sit through a half an hour sales presentation, I think that's fully consideration. So as Charlene said, when you're doing a sweepstakes, you can't have consideration because you would then have consideration, chance, because sweepstakes are characterized by random drawing and a prize. So if your marketing folks come to you and say they want to do one of these types of promotions that I just said, say we'll use the picture of the product example, you say, oh, we've now created an illegal lottery. How do we get around that? Well, there's an answer to that question. The alternative means of entry. So AME for short. Alternative means of entry are a form of entry where there is no purchase or no consideration required. You see these all the time when you look at rules. Maybe you guys don't look at rules, but I look at rules where they say all in caps, no purchase necessary. A purchase will not improve your chance of winning. So this is what it means. And if you look at a promotion where they're seemingly requiring a purchase, but they have that language, there is an alternative means of entry, oftentimes buried in the rules, which is not great. But you have to let folks enter through a non-consideration method and make those entries have an equal chance of winning as the regular entries that are requiring the purchase or some sort of other form of consideration. So postcards are pretty much sort of the old standard acceptable way to do this. The sort of classic example here is McDonald's. McDonald's, I think they still run. Do they still run the Monopoly promotion?
I think so.
I don't know. I haven't been to McDonald's in a long time, although I do like their fries. So they ran that Monopoly promotion. I remember it from when I was a kid. You got those little, you got the little pieces when you bought a Happy Meal or fries or a drink or something like that. And so you might be saying to yourself, well, how do they do that? Because you have to purchase the fries, and then you get, there's some chance involved in what pieces you get. And then there's a prize. So if you looked at the rules, they say that you can write in and set a self-addressed stamped envelope or a postcard or something like that. And you get and they'll mail you a free piece. I believe there's one state, it's not entirely free because obviously there's a stamp on the postcard, or, self-addressed stamped envelope. The law used to, I think in Vermont actually says that the stamp is consideration. I think it's the only state that really ever said that. The interesting twist here is that when I've had clients want to do promotions where you can enter multiple times. And so if we say you can enter multiple times by posting a picture multiple times on social media, say once per day, and there's a 30-day entry period. So you can do it 30 times. So can we let people enter for free doing 30 postcards? Well, I don't actually know what a stamp costs these days, but once you multiply that number by 30, it's not insignificant, and I don't think that's free anymore. And I think most states would say you've crossed a line there. So you have to think about that. You can't just automatically go for the postcard method. You can do emails, but when you do emails, you have to think, okay, how long does it take somebody to send one email a day? And you add up all that time. Are you still sort of in the 5-minute zone? Maybe. But if you're letting folks get, I don't know, 10 or 12 or 30 entries each time they post a picture, you have to think about the time and the equivalent and how to make the free entries be equivalent to the paid entries. And so again, this is a really fact-specific inquiry when you're doing this. I feel like we've got a lot of questions.
Hey, yeah, Fara, I'll throw
chat.
a couple your way. Okay, so two that we may not need to discuss, in depth. But so one is, do likes or follows on social media constitute consideration? And then another one, a donation to a nonprofit that doesn't directly benefit the marketer, but might otherwise be considered consideration. So do you want to think through those two a little bit, maybe?
So let's do the nonprofit donation. So the nonprofit donation, what I think about the nonprofit donation is that it's a payment in a way, or a donation. And so I think to be on the safe side, I would say that is consideration, even though it doesn't directly benefit the sponsor, and say you're just choosing a third party, 501c3, and you're saying, oh, we're doing this promotion, we're creating all this goodwill, but donate money to somebody else. I think that counts. I've definitely done sweepstakes for nonprofit clients, and instead of having the no purchase necessary language, we write no purchase or donation necessary. And so I think the safer thing to do is to still have an alternative means of entry there. You had asked about likes. So likes and follows. This is an area that has evolved over time. At one point, they're called like-gated promotions. And at one point, Facebook actually had said no like-gated promotions. You cannot require somebody to like your post or your page in order to enter a promotion. They've actually removed that, at least the last time I looked at their rules. And we're going to talk about that a little bit later. But and I think that the Federal Trade Commission has taken a stance on this, and I think they don't love it, but they think that it's okay. They feel like it does suggest some sort of material connection, but which we're going to talk about later. But there's really no way to disclose the material connection when you like a company. So they're not in favor of it, but they realize that there's technologically not a way to disclose. And so is it consideration? I think it's probably not, but I don't know that there's been an official opinion on that.
Great. I think in the interest of time, we'll move a few of these comments that are in here. We're actually in the chat. We're actually going to get to later in the presentation, covering some of these ideas.
Okay, so we're going to move on to chance now. So how do you determine where, when there's chance? You can imagine a lot of different scenarios where there's some chance, there's some skill, there's a mixing. Is hole-in-one golf chance or is it skill? Is poker chance or is it skill? I don't know. So there's actually a fairly developed state law on this, a sort of a body of state law, and there's sort of 4 different schools of thought on this, and different states fall under different categories. The first is the dominant factor test, which is the most common of the doctrines here. And so I'm just going to read a little bit from my notes. As I said to Charlene before, this is an open note test, so I can read a little bit because this one's a little bit difficult. But so the dominant factor is sort of characterized by participants must have distinct possibility of exercising skill, sufficient data upon which to calculate an informed judgment, and an opportunity to exercise skill. And the general class of participants must possess skill. Skill or the competitor's efforts must be sufficiently governed by the results, and the standard of skill must be known to participants. This standard must govern the results. So when you're trying to remove chance in a state that follows the dominant factor test, what I recommend to clients is that you say you're doing an essay contest. You don't say, we're doing an essay contest. We're going to select the best essay. What does that even mean, best essay? What I suggest is that you set up a panel of judges and you say it's going to be judged by a panel of judges based on these 4 criteria, and then you give percentages for the criteria. And so you lay out creativity, fit with our brand, writing style, something like that. And you really give them some type of objective criteria to judge that. And then you have judges who are mindful of those criteria. And what I also recommend to clients when you're doing this is you take the judges and you create like a spreadsheet, and you have the judges score each entry on each of the objective criteria, and you keep a ledger in the background. If anybody ever questions it, if an AG comes to you and says, oh, we think that this was completely unfair, and someone complained because so-and-so won and they thought their entry was better, they saw the entries, you've got some objective evidence in the background to say, hey, no, we did this the fair way, we did it blindly, we checked all the entries, and this is our log. And so I recommend to clients to keep those. Material element tests, it's less so used, but it's still used. Is the element of chance present to a material degree in determining the winner? Contest of chance is a, quote, contest, game, gaming scheme, or gaming device in which the outcome depends in a material degree upon the element of chance, notwithstanding that the skill of the contestants may also be a factor. That was from the Alaska state statute. They follow the material element test. They've actually held that, and I believe Hawaii also follows that test, that slots are deemed chance under this. So you can imagine that, I guess there's some skill in slots. I don't know, I'm not a gambler, but that chance has a material element in slots. It seems only fair. Charlene's laughing. And then any chance is sort of what it says. If there's any chance involved, this is a much stricter test. You're really sort of cooked. You're kind of always in the sweepstakes boat. And so you got to be careful with those states. There are fewer of them. Arizona does sort of follow this for certain types of promotions, but they have some exceptions for amusement gambling and things like that. So you think about the state fair sort of pay for a ticket and you do some random game or whatever, that probably has some chance in it, but they think it's okay.
Yeah, I read recently this sort of chance test in terms of like poker being more a game of skill, but any dice game being more a game of chance, or having a much larger element of chance. I don't know how I personally feel about that, but there's this like delineation, like poker versus roulette and dice versus, anyway, it all is very blurry, but.
Yeah, and I believe there are, I'm sort of going off memory, I believe that different state AGs have issued advisory opinions and sometimes actual opinions that poker, in certain states is a game of chance, and in some states it's a game of skill, and you can kind of see that based on these tests. The pure chance doctrine, again, that's sort of like the fourth one. It doesn't really apply in the United States. I don't believe that any states really follow it. I think this was sort of the old British rule, and it just is what it says. If there's, something is pure chance, and I sort of don't even know what example that would be. So it's sort of silly, but it's there. So we can look up a couple examples: chance or skill, random drawing. Clearly, this is pure chance. You put numbers in a hopper like they do with the state lotteries, and there's really just nothing beyond chance there. I think it's pretty easy. Trivia questions. I think trivia questions fall under skill for the most part. I think there are probably some very bizarre. where they might not be. But you can also think of a situation where, in a Jeopardy type situation, I'm a big Jeopardy fan, where there's some chance involved there, because hitting the buzzer is not really skill. Who has faster reflexes? Maybe it's some skill, but frankly, I think it involves some chance, and if you hit the buzzer first. So, that could be sort of a mixed one. Essay contests, we sort of already talked about. Photo contests, they sort of fall in the same bucket there. Poker and hole-in-one, we've talked about. Popular vote, that's an interesting one. If we go back to our definition under the dominant factor test and some of the things that I mentioned, one of them was, are the judges, judging based on some criteria? And so if we're just doing popular vote and we say to the fans, vote for your favorite one, that doesn't feel very, that doesn't feel objective criteria to me. And it doesn't really feel like a lot of skill is being used. And you're not asking people to say, attribute X number of points to the creativity or to the originality. That just feels like vote for your friend's stuff. So that kind of falls more in the chance bucket to me, if you ask me. But if you sort of set it up and you say, vote for the one that best does this or does that, and you try to give the public some criteria, you could probably move into that zone under the dominant factor test. And it also probably depends a lot on what are the entries. Are the entries something that required skill? Do the contestants have any skill? Are we asking our entrants to do an essay contest and then to vote based on on the best essay? So it's a very, again, fact specific. I find myself saying this a lot today. Determination there with the popular vote, but just some issues to think through.
Fara, I would say
any questions?
What this sort of one size fits all that people really desire in this area, the idea of like a set of rules or a concrete resource where you can find X or Y is pretty difficult. I would say FTC guidelines definitely have, someone asked this question, definitely have a lot of guidance around what should be in the rules for a promotion, what needs to be there. That is helpful, but there's no like one set of guidelines for either, online platforms or state laws that I've ever found. We do have a question, which is like a baseline question that probably is on a lot of people's minds, is, does it matter where the contest takes place or where the participants reside? And that's sort of it's a great question. It's a baseline like threshold. So Fara, why don't you answer that really quickly, because I think it's probably
Yeah, it's a great question. So in your official rules, which we'll talk about a little bit later, you're going to say, as we mentioned before, who's eligible to enter. And so when you say this contest is open to residents of the United States, or this contest is open to residents of, Colorado, that's who you are targeting. And so that's where it makes a difference. I think that the AGs of a state, regardless of where you as a sponsor are located, if you are targeting the consumers in their state, they feel that you fall under their jurisdiction. And so I think that's what you need to be mindful of. And so later on, we're going to talk about whether, making the decision to exclude residents of certain states based on certain requirements. And if you want to sort of get around those requirements, you'll see oftentimes, or if you hear on the radio, if anybody still listens to the radio, open to residents of the United States, excluding New York and Florida. And we'll talk about why New York and Florida often get excluded. Somebody also asked a good question I see here. What if we use a panel of judges based on criteria to determine the finalists and then use public vote for final decisions? Does that change anything? Yeah, it does. I think that, it depends on what test, obviously, you're falling under, which states you're looking at. But in that situation, I think that there is a material degree of chance involved. If you're doing a public vote and you determine that the public vote is under the chance, I guess I should make that statement. But it's also a good sort of practical tip. The way that you set up this question was good, because it's a two sort of levels of of the promotion. And what I always recommend to clients when they want to do a sort of 2-level or a multi-level promotion, when they're picking sort of a finalist, is, make sure you think about where it's the judges that are your own controlled judges versus the public voting. So if you do the public voting first, and then you do the controlled judging afterwards, you could end up with, say the first round goes from 100 entries to 5, and then you pick the finalist for the based on the panel of judges, and you get that, say you're picking a photo or an essay or a brand ambassador or something like that. Well, you could end up with 5 entries that you as a brand hate, and you could end up with a really terrible result and not want to make this person your brand ambassador or not want to publish this photo. The really great example is that there was a contest in Britain, I believe, where they were naming a ship. It was a large, shipping vessel, and they did it by public vote. And they ended up having to name the vessel Bodie McBoatface. So let that settle in. If they had, narrowed down the finalists using a panel of judges and then let the public vote on the 5 finalists, they could have been fine with the 5 finalists and said, okay, fine, we'll just leave it up to the public to select the final winner. But that's not the way they did it. And so they ended up having to name this vessel Bodie McBoatface. It's actually pretty embarrassing if that's not something that you're into. So pretty funny. Okay.
The third
So prizes, yes. Charlene, you're going to start us off here.
Yeah, I'll do the first 2 here. So third leg of the chair, prizes, tickets and other restricted items. So keep in mind, certain tickets and other restricted items cannot be given as prizes. Their resale or transfer might be restricted. So it's important, I think, in the rules for the promotion to create options to give away something that is of equal or greater value if the thing that is the prize becomes unavailable for some reason. I'd also say that this would be helpful in the event that the event is canceled, for which the ticket provides you entry, is canceled or rescheduled, say like in the event of a pandemic or something crazy like that. It would be good to have your rules for your promotion address these types of issues and keep your eye on that ball. Trademark issues. So you want to be careful. This was actually a question earlier up in the stream, I think, from Lindsay, about giving away a physical prize that is branded. So I think the example in the chat was like an REI gift card. And, can you talk about the fact that you're giving away an REI gift card or a Gucci bag or, something like that? And the answer is, under fair use principles, you can accurately identify the brand of the prize that you will be giving away as part of a promotion, but you have to be careful, one, to comply with the rules that relate to the trademark fair use rules. So, not using more of the mark than you need to convey the fact that this is an authentic, Gucci bag or an REI gift card, not using logos, things like that. So that's kind of a different seminar. That's a trademark seminar, an infringement seminar. But what you also want to do is be careful to make sure that the language and the advertising that you are creating around the promotion does not make it appear that it's a co-branded promotion. So you don't want to make it look as though REI has joined forces with you to create a promotion where you're promoting your product and they're promoting their goods via this gift card. So you also want to keep your eye on that as it relates to the advertising around the promotion you're running, to make sure you're not creating the appearance of a co-branded promotion.
Great. And that issue comes in a lot when the marketing folks say, hey, let's do the Dorsey REI gift card promotion. Yeah, we don't want to call it that. We want to call it the Dorsey outdoor, get outside promotion, outdoor promotion, something like that. Sometimes it's worth doing a trademark scan or even a trademark search when you are naming a promotion. If you really want to pick an interesting distinctive name for a promotion, if you're really going to do a big based promotion, it's worth, checking with the trademark team and making sure you're not stepping on any trademark toes. This issue comes up every year around the Super Bowl. It comes up.
I like how you whispered the word Super Bowl, Fara. Super Bowl.
It's really just called the big game. Don't call it anything else. With the Super Bowl, with the World Cup, any kind of award show like the Emmys, Oscars, things like that. You can do a red carpet promotion, but you should not be doing an Oscars promotion unless you have permission from the trademark owner. And I think the sort of trademark clearance issue too can be one, it's relevant to run any promotion, but particularly if you're trying to create a brand around a promotion, right? So like if you're gonna have an annual promotion or even a semi-annual or something more frequent, you might actually consider whether creating a brand around a promotion is a good idea, and in that case, of course, running a clearance searching and taking some affirmative steps to protect it would be a good idea. And so we have a question. So the idea is, are you kind of safe from a trademark perspective if you just avoid use of the brand for the prize in the name of the promotion? And I would say that's a really good place to start. I don't know that will make you safe for all purposes if otherwise the language you're using in the advertising for the promotion makes it appear like there's more of a relationship, or if you start using logos for Amazon or other things that take you out of a fair use and context for trademark infringement purposes. So I would say, yeah, a great place to start. I'm not sure that's the end of the inquiry. Yeah. But again, fair use, if you're giving away an Amazon gift card, you can say that you're giving away an Amazon gift card. On a base that is fair use. But how you say it is in the context is what's important for legal review.
Yeah.
So the next bullet point here, describe the prize in detail. So gift cards, pretty easy. I'm giving away a $25 Amazon gift card. But what about you're giving away a trip to Los Angeles? So what are we including there? And is it an all expenses paid trip? That's probably not enough to say, because if somebody is giving me an all expenses paid trip to LA, I'm flying first class. I am drinking champagne on the plane. I'm going to take a limo to the airport, and I'm going to stay in the nicest hotel, and I'm going to eat caviar and, drink expensive wine for the entire trip. And if nobody told me that wasn't okay, I'm going to be really upset if it's not okay, or you as the sponsor are going to be really upset when you see the bill for how much I've spent. Managing expectations is what this game is all about here. Tell folks what you're giving away in excruciating detail in the rules. That's why the rules are there. Tell them that you are giving away, two, regular tickets from the state, the closest airport to where somebody lives, to LAX. Ground transportation, is it included? Is it not included? Are baggage fees included? Are they not included? Is dinner, does dinner, you can cut off the value of dinner at, $500 or $100 per person or something like that. It's better to have capped limits on there. If you go over, no one's going to complain. But if people expect that they are going to be able to eat at any single restaurant and spend any amount of money, and then you tell them that they're having dinner at McDonald's, it's going to be a little bit different. So be as specific as possible. When you're giving away physical prizes, you're giving away a phone, tell us what model phone, tell us what the size is. Sometimes there are variables that can be left up. So if you're giving away, I don't know, a cell phone, and is it going to be, set up as an unlocked phone? Is it going to be only for a certain, wireless carrier? Tell us what the requirements are, because maybe people don't want to get that prize. And then, as Charlene mentioned before, always put in the official rules that if a prize becomes unavailable or circumstances change, that sponsor has, the right within its discretion to substitute a prize of equal or greater value. That's super important. Like Charlene said, pandemics, supply chain issues, things like that. It's very important to put something like that. Actual retail value, this again is super important when you're putting together a prize with multiple components. It's important to say the individual values of the different prizes and then the overall value as well. And we're going to get to why that's important for a couple of reasons. One of the reasons is because you need to give, as a sponsor, a 1099 to all people who get prizes that have an individual value of $600 or more. So if you stay under $599, you don't have to give 1099s. If you give away, 100 prizes of $100 each, no 1099s are necessary. If you give away one prize of $700, you need to issue a 1099. It's not about the overall value and the complete value. It's about the individual value. Mm-hmm. So that is super important. And then the other reason why we talk about the values here is for registration and bonding purposes. So registration and bonding, to be clear, in the United States only applies to sweepstakes. It does not apply to contests. If you are having a contest of skill, and that's often why actually we've spent so much time, we sort of hid the ball from you guys. We've spent so much time talking about chance versus skill. If you fall under the chance, and so you're on the sweepstakes side, and you are having the the open to residents of New York, Florida, and sometimes Rhode Island. We're going to leave Rhode Island aside for right now. New York and Florida, if the aggregate value of the prizes is more than $5,000, you need to register the rules and the promotion and bond. So for you in-house folks, this is sort of lights should be going off if you see the total value of the prizes $5,000, more than $5,000. So you're going to need some lead time. The rules have to be finished in order for you to register and bond. You need to go get a bond. You usually do that through your insurance brokers can help you get a bond. You need to bond for the total value of the prizes. So if you're giving away $10,000 gift card, you need to get a bond for $10,000. And New York has a weird rule where they sort of say this does not apply to video entries. I guess they've decided that video entries are not chance and they're only skill. So don't try to register a contest with video entries. Florida doesn't have such a rule. So if you think it's a chance based promotion, it's a sweepstakes, go ahead and fill out the forms and register. I feel like each one requires a $100 fee, something in the neighborhood of that's not the most of your costs here. The most of your costs here will be in the bond. I think it's a percentage of the total value. You need to do it 30 days ahead of time for New York, and you need to do it 7 days ahead of time for Florida. And so those are sort of key timing considerations. So if your marketing folks come to you and say, we want to do this great promotion, we're going to give away $10,000 to residents in Florida tomorrow or Monday or something like that, that's not going to work out for you. You're going to need a little bit more lead time. Rhode Island is particular in that it's only for in-store promotions. Candidly, I've never done a registration in Rhode Island before because people just don't have in-store promotions much anymore, and it's only for prizes over $500. But I guess there's no bond required. Here on the next page of the slides, I've given you guys some links to the forms to fill out for the bonding and registration. Both states have really comprehensive information for you guys to read and go through. There's little PDF packets online. It's actually pretty user-friendly. I don't feel like you need outside counsel to fill out those forms. They're actually pretty easy to fill out once you kind of get the gist of it, and the directions are pretty clear. Some people are asking some questions about the 1099.
So so it says 1099 are based on ARV, correct? Not the company cost if we're giving away a product.
Correct.
Correct. 1099 gift card, I'm going to run through them a little quickly, but 1099 gift cards, the 1099 is issued to cover the year in which the card was issued, not when the gift card is actually used. So directionally accurate, but I think there are rules on what, there are tax rules that govern when you have to postmark the 1099 to the winner and what year you have to send it to them in. And I think I just looked this up, so I know it's the year following the year in which the prize was won. But Fara and I are not tax lawyers, and this is very much a tax question. So I think your comment, Holden, is directionally accurate, correct? It doesn't relate to when the gift card is actually used at all. There was a question here, and this is interesting for us. I just want to read it, but it says, what about when there aren't enough entrants in a sweepstakes or not enough good entries in a contest and the marketing team wants to extend the deadline? We generally say no. Is that the right approach?
Yeah, I think that is the right approach. So it's a nice lead into the next slide
here.
Official rules. So we don't have a ton of time left, and so we may not spend a ton of time on this slide. But Charlene, as we've discussed, many times, official rules are contract between the entrant and the sponsor. And so once you've started the promotion, you cannot change those rules. So it's very important to make sure that you have everything down there that you want. And so if you anticipate maybe having trouble getting enough good entries, I suppose you could try to write in a provision that says, if we, in sponsor sole discretion, if we don't get, 50 or more entries, we could extend. I've never done a promotion like that, but I think you could do a promotion like that. I've done some different ones where it's a contest and we say something to the effect of, if the panel of judges determines that none of the entrants are of quality, above a certain score or something like that, then the competition may be canceled or something. And those are difficult to do, but I think there's a way to do it.
Yeah, I think it's all, like you said earlier, Fara, about setting expectations, right, with the rules. And you mentioned earlier, with the prizes in particular, like, tell us everything we need to know about what we're getting and all the limitations and all of the restrictions. So some of you out there are thinking, okay, so how am I putting all of these official rules in this tiny TV spot or this radio advertisement or online in this social media arena? And I guess, Fara, do you have to put the complete details of the promotion in the one shot, or can you put minimal disclosures and provide full details elsewhere? And what would you say are the top 4 or 5 big ticket items you would put in a minimal disclosure, let's say?
So if you're doing a sweepstakes, always put the no purchase necessary to enter or win. A purchase will not increase your chance of winning, in caps. Put that in the sort of short form rules. You should also put all the material terms in the short form rules. If there's a requirement, if there are eligibility requirements or restrictions, put those in. If there's a time to enter and when the winner will be selected, things like that, the material terms should go in there. And then also super important is to put in subject to complete terms and conditions or subject to the official rules. See link for details and then link to the full rules. The full rules are often, a couple pages long, depending on how complex the promotion is. And you don't have to put all of it in the short form rules, because nobody, requires you to do that. But it's important to provide the rules somewhere. And on that note, when you're doing an Instagram promotion, for example, you cannot put links in Instagram posts, and you don't want your comments to be, 8 pages long. There must be some limit to the length of a comment on an Instagram post. I'm not familiar with exactly how long it could be, but, put your short form rules in there. And then the best practice I recommend to clients to say, link to full rules in bio, because, you can put one link in your bio on Instagram, in your profile. And so be that that link for the duration of the promotion. If you're not willing to do that, put in a URL that somebody's going to have to type in and go to in the comments, and make it easy. Don't make it super long. Don't make it super difficult. The other option, I suppose, is that, you know, a lot of branded Instagram pages, you know, have one link in their bio that takes you to sort of a web page that shows you pick different pictures, and then you can link to the shopping or the story or whatever, and then you could do a separate link. But it's super important to do that.
I'm going back to a comment from EM Stock that I tried to reply to you in the comments, but realized I can only send my replies to hosts and panelists. Apparently they don't trust me enough to just launch them to the full group of people. But if you go to the next slide, Fara, unfortunately, there is no one set of rules for promotions in online social media, social networks, or online platforms. I wish there was a set of resources you could clink through to make sure you're complying, but there isn't. The platform rules vary. They're each individual, and I would say they change relatively frequently. Relative is relative, but in my mind, they change relatively frequently. And I think the best thing is to, wherever you're running the promotion, whatever the online platform is to review those rules real time and make sure that you're complying. But there isn't, unfortunately, one set of rules or one place to look. But each platform does pretty much. I actually looked at a few today. Even Eventbrite has their own little set of rules, and I would check those out. The FTC does have .com disclosure guides, and they provide guidance for effective disclosures in digital marketing. And this relates to the third bullet point a bit, but basically Section 5 of the Act requires the disclosure of a material connection between a marketer and an endorser, and entry into a contest to receive a prize or significant prize in exchange for endorsing a product through social media constitutes a material connection that has to be disclosed. So now we're sort of wandering into this endorsement field, and the FTC has issued, there's these two pieces of guidance up here. The first one is basically, I think, for the Cole Haan FTC case kind of in a nutshell, but Cole Haan ran a promotion. It was on Instagram on Pinterest, where contestants, contestants were instructed to create boards where they would include 5 images of Cole Haan's shoes from their board and 5 images of like their favorite places to wander. It was called Wandering Soul. And they would use the hashtag Wandering Soul in their each pin. And Cole Haan promised to award a $1,000 shopping spree to the person with the most creative Pinterest board. The FTC took issue with this and found that the participants, that the average consumer wouldn't have realized that there was a material connection between these endorsements and the fact that they were receiving this $1,000 shopping spree, and that Cole Haan should have had contestants label the boards appropriately or use a hashtag that made it clear that they had pinned the Cole Haan products as part of a contest, because that created this sort of material connection. So this first FTC guidance piece right here is basically the Cole Haan case. Like, use the word contest or sweepstakes as part of the hashtag. That should be enough to make the disclosure for the person who has now become the endorser for this brand by virtue of the fact that they're trying to participate in a promotion by making a post or having this board with pins. The second one here, I think, go ahead.
So Charlene, I'm just going to interrupt you for a second because we are at 2 o'clock. We're going to keep going just for a little bit. We get if folks have to jump off, but we appreciate everybody joining us, and we just have a couple more quick slides to do. So keep going, Charlene.
Yeah. So the second one here is, what if I get all I get from a company is a $1 coupon? Is this really, material? And what kind of a gift or incentive is material for purposes of disclosure? And I think this guidance very much says, like, better be safe than sorry. It's best practice just to disclose it if you're getting anything of value. And I won't spend more time on this, Fara, in the interest of moving.
Yeah. All right. I think this this slide is me. So advertising giveaways, we've covered a bunch of this stuff, so I'm not gonna talk too much about it. But the third bullet point there, fair, not false advertising. Again, be honest with your consumers about what you're giving away. If you're giving away a car for them to own, you're giving away a car for them to own. If you're giving away a lease, you're giving away a lease. Just be honest and say what you're giving away, because that's when you get into trouble and people get mad and they contact attorney generals, and that's when you get enforcement actions against you. So, and we've touched on all these other points. We do want to cover this quick example for those of you who are still kind enough to give us a little extra time. So, Charlene.
Yeah. Draper James, some of you may know, is Reese Witherspoon's dress company. Early days of pandemics, spring 2020, there was this Instagram giveaway, which said this: "Dear teachers, we want to say thank you. During quarantine, we see you working harder than ever to educate our children. To show our gratitude, Draper James would like to give teachers a free dress." After nearly, I read this morning, 1 million teachers entered their information to receive a free dress. The company disclosed that it only had approximately 250 dresses to give away. So, Fara, like, what happens here?
Yeah. So, this is sort of, Charlene alluded to this before. It can become a PR issue, and that is exactly what happened here. I don't think that Draper James followed best practice and disclosed up front that this was in fact a sweepstakes, and they were going to randomly pick winners, and they didn't say how many prizes were being given away from the get-go. Was everybody getting a dress? Was this not a sweepstakes? Were there 200 dresses, 250 dresses? Were there 5 dresses? You didn't know from the beginning. You just said, great, we're working really hard. My husband's a teacher. They were working really, really hard in the beginning days of the pandemic from home, and it was impossible, and felt like, wow, this is great. This is goodwill. And you needed to log on and give your ID. So there are some privacy issues involved there about what they're going to do with your personal information and what are you signing on for. But, folks on Twitter got really upset, and I think rightfully so, because they didn't realize that they weren't getting a free dress. There were only 250 of them were getting a free dress, and there were 1 million people that signed up for this. So, I think that's problematic. And if they had known from the beginning, I don't think that would have been a problem. And so this, this sort of brings us back to disclose, and make sure that that folks know what the promotion is about and what it's not about.
And I think actually there was a lawsuit in California by a consumer action in California against Draper James. It didn't go very far, but the crux of it was that well, I shouldn't say it didn't go very far. I'm not sure of the current status as I sit here, but the crux of it was that Draper James had intentionally done this as a fraud to get tons of people to submit information, because in the year prior to this promotion, Draper James had only sold something like 650,000 dresses. So they had effectively doubled their consumer base, right, just through one promotion, by failing to disclose this information, which they knew would draw a bunch of information from and create this base of quote unquote consumers or information for them to use. So there was a fraud case brought that this was intentional, was defended or is being defended. Yeah. Interesting.
That's interesting.
Get yourself into a load of trouble.
I did not know that there was a lawsuit about that, but class action lawsuits, California, those plaintiffs lawyers will do anything to file one of these lawsuits. And so if you are a big brand and you're doing something like this and it gets a lot of press, I mean, there was an article in the New York Times about this. So it was very widely reported about how poorly this promotion went. So,
defeats the purpose of running a promotion to create goodwill and, brand recognition.
Yeah.
When it's just negative. Yeah.
Yeah. So this is our last substantive slide here. So as we promised in the teaser for this webinar, we were going to talk about influencers and promotions. So I get a lot of questions from clients. How do we get our influencers involved in our giveaways, and can we have them run the promotion themselves? So the best practice is for the brand to sponsor and control the promotion, and for influencers simply to promote the promotion. We've talked about a lot of legal issues today. There are a lot of laws that are implicated, federal laws, state laws, international laws. And so if you let an influencer run the promotion, you're handing over a lot of legal risk to a person who may, just be sort of a solo kind of operation, especially if they're a micro influencer, maybe they don't even do it full time. Do they have access to legal resources? Do they know about this stuff? It can be quite daunting, I think, for an individual person. I'm sure there are certain sort of higher level influencers who work with influencing agencies who can fully run a promotion up to perfect legal standards, but those are probably few and far between. I would be remiss if I didn't tell you that really the best practice is not to let your influencers run promotions for you. That's not to say that influencers can't promote the promotions. They can certainly do that. Disclosure is key when they need to do that. And you could as part of your promotion say that you could include maybe the influencer's name and a hashtag, or you could say you could require a follow for the influencer's Instagram account and your Instagram account as part of the promotion. That's not not against best practice, but it makes me nervous when clients really push on this. And I have had a bunch of clients push on this because they really want to reach the influencers following, and they're not going to reach the influencers following as much if they do it off of their own account. And the marketing people have said, well, but even if they're just promoting our promotion on their own account, we don't love that. So, an alternative, but there's more legal risk involved, is for the influencer to do the promotion on their own and for the brand to be a prize provider. And like I said, it's higher legal risk, but it does sort of make room for this scenario that the marketing people have pushed for. Even if you have the influencer exclude you in the liability clauses and things like that, under the rules, there's still a risk that you could be pulled into it because you as a brand are really the deep pocket here. And so it's something to watch out for. I think that we are about 10 minutes over. So Charlene, anything else that you want to cover there?
No, and I think in the interest of letting people get to their day or their lunch, wherever they sit right presently, we can probably wrap up. It's been great to have you. Holden, if you're still on the line, thanks for staying. Appreciate your time very much, everyone. Please reach out to Fara or I if you'd like to continue any of the conversations.
And please look for part 3 of this series. We're going to be talking more about influencers, and we can go more into depth about influencer promotions if that's a topic that people are interested in. And we will see you next time. Thanks so much for joining.
Thanks, everybody. Take care.